to Employment Law This Week. I'm George Whipple. Our top story, the EEOC wants your pay data. The Equal Employment Opportunity Commission has proposed changing its EEO-1 forms. The forms currently require employers to provide information about the gender, race, and ethnicity of their workers across 10 different job categories. The proposed change would add a requirement that employers submit information pertaining to an employee's hours worked and report W-2 earnings across 12 different pay bands. If the proposal is implemented, employers will use the new forms beginning in September 2017. Peter Stein has more.
EEOC is hoping that with the collection of this data and the analysis of this data by employers, it will force employers to confront their own pay compensation systems to determine whether there are any pay disparities that exist and need to be corrected. To the extent that doesn't happen, EEOC will use this data to assess discrimination complaints and perhaps target employers for further investigation.
And more from the EEOC this week. The agency recently released 2 different guides on the rights of HIV-positive employees. The first guide outlines employees' rights under the ADA. The second guide is for healthcare providers with HIV-positive patients. It encourages them to advocate for their patients' rights in the workplace. These documents are also valuable resources for employers. Among other takeaways, they break down the process involved in a request for reasonable accommodation from an HIV-positive employee. The Department of Labor sends its proposed fiduciary rule to the White House. The new rule would impose stricter conflict of interest rules and fiduciary requirements on advisors working with retirement plans and investors. Critics of the DOL proposal have charged that it would prevent those who cannot afford highly individualized advice from receiving basic retirement planning services. As with the EEOC, the Department of Labor is making a big regulatory push in President Obama's last year in office. Next on the horizon is the department's contentious overtime rule, which will most likely go into effect in July. The New Jersey Supreme Court confirms that anti-harassment policies are critical to a defense against vicarious liability. In New Jersey, an employer may avoid liability for workplace harassment by showing that it exercised reasonable care to prevent and promptly correct any harassment, and the employee unreasonably failed to complain about the harassment. In declining to hear a recent case, the court re-emphasized that only an employer who has instituted effective anti-harassment policies and procedures can use the defense. And after the fact, remedial action alone is not sufficient. Finally, it's time for our tip of the week. Here's Richard Noe, General Counsel for BT, on the legal landscape for employees' use of personal devices for work.
BYOD, or Bring Your Own Device, is something that is really permeating all of the corporate landscape. And there are a lot of implications that you need to consider. You need to consider what your policies are, and your policies really have to map to the security policies as well as the contractual obligations and back to the law. Encryption is very important. There needs to be a secure wrap around the corporate data on top of the device. This is important for a whole host of reasons to make sure that the information stays protected, but it's also important when thinking about what is it that the company is going to be able to reach out and wipe when a device is lost or stolen or subject to malware or anything like that. Another hot topic for BYOD is e-discovery. It used to be that corporations could go out and lock down a lot of paper. We then had a period of time where it was about the computers. With BYOD, we're looking at how do you actually go out and gather data that could be on the personal devices of a number of different employees. And that's a very difficult aspect of BYOD to manage, but it's critical in the context of litigation.
Thanks, Richard. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.